MHRD, Department of School Education, Government of India, whereby candidates possessing qualification for B.Ed have been made eligible.
That Supreme Court has watched.
Now kindly come to the 7.2. The Honorable Court may kindly please to issue an appropriate writ order direction not to treat the B.Ed candidates as eligible for the post of primary level teacher. This relief has already been granted by the Supreme Court.
What is granted is to continue appointments. Supreme Court has not reseated anybody. Supreme Court has only stopped any fresh appointments. And
I'm sorry, that's a wrong statement to make. That's a very wrong statement to make.
I'm appearing in those
Very wrong statement to make. Because we have produced those writ petitions.
The state government is not ready to argue.
Because they don't want to argue because they want to protect a specific. They are not wanting to argue for reasons best known to them.
On that, by regarding that statement.
Kindly see every time the state and every opposite council wants adjournment on one ground or not. This adjournment matter is actually in their interest. They want this person to be continued in violation of Article 21A. Any single adjournment matter would be at the cost of the children who are being taught now by the referring teachers. The Supreme Court must be out of violation of Article 21A. That's the one to be made party with adjournments day after day on one count or another matter. Supreme Court did not take an argument. It's a matter for petitioner's arguments.
as far as we are concerned, the judgment is clearly distinguishable on facts, my lord, and also we are very well protected.
Even otherwise, it will take time to be heard.
Yes.
Because it won't take time, my lords. May just give us 5 minutes and we'll be done. Just 5 minutes.
But then
5 minutes to show that nothing remains now. Just 5 minutes.
I'll not make any submission.
So much of opposition, even on hearing. Imagine what
Because for obvious reasons, because they are placed. Obvious reasons.
Energy for the counter petition. My energy transfer petition is actually miscarriage of justice where you are more than happy to kindly tell that to the Supreme Court. And now kindly say that to order. What do you think comes from state of UP? There was no order. It's a writ petition filed under Article 32.
Because I am appearing in that writ petition, Guru Singh, there is absolutely no connection. I am appearing in that matter. For some of the DLED candidates, there is no connection of issue. And my lord would recall that every time there is a new ground coming for adjournment. Why? Because these DLED candidates are serving.
Anna Ghosh is not decided, your lordship will deal it on merit. Anna Ghosh was dismissed. If they were heard, Anna Ghosh was dismissed. The lodgement order says that the consequences were to follow. No person who was appointed cannot be saved. There is a lot of silence that in Anna Ghosh, incorrect is same. Absolutely incorrect. I just counter it on the spot and being said that. It is clear that both applications intend to seek for recall of the review of the order passed by this honorable court in the guise of having presentation of the application. The player made in these applications itself would make it clear that applicants intend to seek for re-hearing of the matter of marriage after reviewing the order dated 11 and 2022, which is confirmed under law. Read it petition.
But as far as we are concerned,
always please start the orders.
Very well, my lord. So grateful.
We'll deal with the objection. We will deal with the objection. We will record that you are not cooperating. Yes, please start arguing. Please start.
I'm asking for Manus may just give me 1 minute. Manus, your order time is 7 minutes. Before he starts his argument, I'll start my argument.
Make him start it.
That's my lord.
We will call for your application, whichever is filed is not here with us. No, it's not uploaded. It's not on record. No, we will not see that. We will see the one which is filed. We call it whenever it comes, we will see. Till then, let's start arguing.
Please state 16 first, the application that was filed by Arnab Ghosh. Please see 16 for a minute, and then we can come to 18.
If you can please wait for a minute. This is page 18 of the coalition you are writing. It's David Sharma versus Union of India.
Asking you to join in whenever but we can't. Take it up in the next week. No, I'm sorry. We reject that request. If you want, we can put it down and write. Please start. Please start your argument, Mr.
I started my argument with argument and comes to page table. Number maybe now, Mr. Gadian, would you please allow me to go up and say, we are senior counsel, I hope and I request to learn from you.
Please leave it that to the court. Handle Mr. Leela.
There is no objection in his argument. I'm only saying that the AC Nandan case can be decided first because this has been rendered people. Getting Marfu, the other matter, I have no objection. No, but this AC Nandan case,
which case are you arguing?
I'm arguing in Vipin Kumar Devi. He is arguing no.
Where is that? That is WP.
Well, that is South India. That is the next case. First case is case in and I would like to place the law as far as Nunam is concerned. But I will not take losses to the files because there is a compilation as well.
28.1.
Yes, 38.1.
No, that is Sakshi Trader.
No. 32.
Sorry.
Parties list Vipin Kumar is 32.1, writ petition 595 of 23.
595. Vipin Kumar Devi. I'll just take your losses to this compilation. I'll not take your losses to the files. I'll just be referring to the compilation.
Yeah. 32.1 is Vipin Kumar. Yes.
Now, Madam Secretary, Lordship have this compilation which Madam Rakshi Abraham was referring to because not to bother with the different compilation, please come to this. And let me take your Lordship to the lodgement order at page 18.
Can we show 17 first if you don't mind? 17 is the prayer. The prayer would be important. Let's show the prayer. At 17, what was the prayer in Arnab Ghosh?
17.
Which compilation are you
This is this
talking about?
No, this compilation with Madam Rakshi Abraham was referring.
Yeah.
Is this the compilation of orders, Manoj, that has been filed for convenience? Orders and prayers. Nothing, no reading has been placed.
Yes.
Now, Lordship.
Yes. Yes, please.
Please come to the prayer at page 17. This was the prayer.
17.
Page 17, running page 17. This is prayer number A.
In Arnab Ghosh.
Modify or clarify that any recruitment process that has commenced prior to the judgment dated 2023 passed by the Honorable Court in Civil Appeal number 5068 of 2023 shall not interrupt. The appointment shall continue to be made as per recruitment notifications for recruitment with the primary meters issued prior to the judgment dated 11/2023. So by this prayer, Madam, it is very much clear that most of processes which have initiated the appointments being made should continue and the judgment in itself should have a prospective overruling. The impact is prospective overruling. Now, Madam, what is the government?
Not concluded, that's like 92.
Comments concluded whatever is meant to. Please do not disturb in between. I'm making my submission. You may counter it. Now, Madam, can you come to the next page? The third paragraph. The judgment dated 25/11/2021 passed by the division bench of the Honorable Rajasthan High Court for challenge.
Where are you reading?
This is page 18.
Yes.
This is the order dismissing this application.
The judgment dated 25/11/2021 passed by the division bench of the Honorable Rajasthan High Court was challenged with the Honorable Court in Civil Appeal number 5068 of the 2023 and connected appeals. Apart from the said appeals, petitions filed under Article 32 of the Constitution of India, even with the same issue, were also tagged with the appeals. The NCT notification and issue notification dated 28/6/2018 exercising powers under Section 23(1) of the Right to Education Act 2009, making BA degree holders eligible for appointment to the post of primary school teacher class 1 to 5. When the advertisement was issued on 11/1/2021 by the Board of Secondary Education State of Rajasthan, it excluded BA degree holders from the list of eligible candidates, which came to be challenged before the Honorable Rajasthan High Court. The notification dated 28/6/2018 issued by the National Council for Teacher Education came to be quashed by the Honorable Rajasthan High Court, which held BA degree holders to be unqualified for the post of primary school. Thus, the issue that arose before this Honorable Court was whether National Council for Teacher Education was right in including BA degree qualification as an essential qualification for appointment to the post of primary school teacher level 1. After detailed consideration of rival contentions, this Honorable Court was pleased to dismiss the appeals and confirm the judgment passed by Honorable Rajasthan High Court dated 25/11/2021. It the Honorable Rajasthan High Court has followed the settled legal position and no interference is called for. The said civil appeals have been dismissed in terms of reportable judgment. This Honorable Court, by disposing of the said appeal on 11 2023, inter alia has been pleased to pass the following order. What the Rajasthan High Court has stated above, it is a settled legal position. In a recent judgment of this court in state of Manipur versus V. Suraj Kumar Program and others, this position that a statute has been made by competent legislature is valid till it declared unconstitutional by a court has been reiterated. Consequently, the appeals are dismissed and the judgment dated 25/11/2021 of the Rajasthan High Court is upheld. The notification dated 28/6/2018 is hereby quashed and set aside. The writ petitions and all pending applications can dispose of in light of the above order. The present application for modification of the clarifications filed by applicant Mr. Arnab Ghosh. The prayer made is to modify the judgment dated 11/8/2023 passed in civil appeal by clarifying that the appointments to the post of primary school teachers shall be made as per the recruitment notifications issued prior thereto. This may kindly be marked. For the other applicants, Mr. Achinta Dhara and Ms. Tanishka Das, who intend to come on record through impeachment are persons belonging to the state of West Bengal and BA degree holders are aspirants to the post of primary school teachers. They have applied pursuant to notification dated 23/12/2022 issued by West Bengal Education Board, which is subject matter of challenge before the Honorable Kolkata High Court. It is well settled that applicants cannot seek for review or recall or modification of the order passed by this Honorable Court in the guise of filing applications. Appreciating the tendencies of the litigant in prolonging and indulging in endless litigation, this Honorable Court in the matter of Indian Council for Environmental Action versus Union of India and their manner of referring all these judgments.
25 directly. 25 last part.
Is 25. It is clear that the applicants in both applications intend to seek for recall of the review of the order passed by this Honorable Court in the guise of filing the present distance application. The prayer made in these applications itself would make it clear that applicant intend to seek for re-hearing of the matter on merits after reviewing the order dated 11/8/2023, which is impermissible under law. This Honorable Court has been pleased to reiterate the law and confirm the judgment passed by the Honorable Rajasthan High Court and necessary consequences would follow. This may kindly be marked.
Which appointments made 10 years ago will also
Do not accept what I am saying. My duty.
They are wasting the valuable time of this honorable court, saying something which is not written in the order. You should not say consequences is appointment.
Let him complete.
The applicant intends to re-educate the matter of filing reference application for clarification of the modification which cannot be permitted under law. The other applicants were aspirants to the post of primary school teacher in West Bengal Education Board were not parties, and even according to their application, their challenge is pending before the Honorable Kolkata High Court. The aforesaid principles consistently laid down by the Honorable Court would reveal that no application seeking to review, recall, modification of the order of the judgment maintainable under the same is not envisaged in law. When the said principles are applied to the present application, it is clear that applicants are attempting to re-educate the issue and obtain indirectly, which could not be obtained directly from this Honorable Court. This is very important, my lords. There are absolutely no reasonable grounds made out to the applicants to entertain these applications. For all these reasons, I refuse to receive the present application as it does not disclose any reasonable cause for being entertained and they were dismissed. Now, my lord, this order of lodgement was challenged at page 27. This is what on last occasion respondents referred that the matter is pending with an unknown board. I take your lordship to the last order sheet. Your lordship may now kindly mark this IA number. Please come to the prayer at page 28.
Yes.
Then beside the include order dated 22/9/2023 passed by Learned Registrar Judge Listing MA diary number 36321 of 2023 and directly Learned Registrar to register MA diary number this and this. This matter was referred to the bench which delivered Devesh Sharma's case at page 29. Justice Anuruddha Bose, Honorable Justice Sudhanshu Thulia.
The date is important. 11 January.
11 January 2024. On 11 January 2024, after hearing all the parties in this prayer,
Please see the prayer also, please.
because the idea challenges lodgement order. Dear Honours, after hearing them, kindly see at page 30. We are not inclined to entertain this application, the miscellaneous application. Now, Madam, at this juncture, I will wait. Please come to your Lordship's order of 4/1/2024 in case Srinandan and other connected petitions. to the 4 January 2024 order.
Yes.
Kindly see, my lords, after hearing learned counsel for rival parties and facts which have been brought to the notice of this court, that an application for clarification clearing the MA number 2206 of the 2026 still pending consideration before apex court and is tentatively listed before the bench on 11/1/2024. As per the website of the Supreme Court, it would be appropriate to await the verdict of apex court. Anxiety has been expressed that B.Ed appointees were filed MA 2206 of the 2023 before apex court may delay the matter by keeping the said MA pending for long. In view of all, this court deems it appropriate to observe that on the next date of hearing, if no clarification is granted by apex court, then this court may be free to decide the matter on merits. Interim relief may need to continue till next date of hearing, and then the matter will be listed on. So now this very MA, which was in lordships awaited, this was dismissed by the very same bench which delivered the judgment in the case of Dinesh Kumar. My lord, let me explain it. All arguments not like I do not discuss it.
He has not finished.
I know what. It will help.
No, we can't have arguments piecemeal.
No, when this was done, the things now which have become very much clear is that the B.Ed candidates who were the beneficiaries of all those advertisements issued prior to 11/8/2023 approached the Honorable Court in a pretext that judgment of Devesh Sharma should be treated to be a matter of prospective overruling. All appointments made, all process initiated, they should terminate in the benefits of the B.Ed candidates being treated eligible till the notification was quashed. Now, that clarification, the lodgement order was dismissed, the application was also dismissed. Now, without wasting a lordship's time, please come to the judgment of High Court of Patna, which was seized with the very similar position which your lordships are seized with. Your lordship may kindly come to compilation page 36. And I'll take your lordships to the page 43.
Yes.
Please come to Maharashtra fact on page 6 by 2023 order. The writ petitions, lordship got it?
Yes.
The writ petitions agitate the issue of consideration of candidates having B.Ed from any national council for teacher education for appointment as teachers in primary schools holding classes between 1 to 5. The stipulation to entitle B.Ed qualified candidates are applicable for teachers posts in primary schools came by way of a notification issued by NCT on 28 June 2018, which has now been set at naught by the Honorable Supreme Court in Devesh Sharma versus Union of India. The writ petitioners challenged the notification before this court by the appropriate petitions in the year 2021. In the meanwhile, a similar challenge raised before the Rajasthan High Court was allowed by judgment dated 25/11/2021, rendered by a division bench of that court. It was said that judgment challenging the same thing was which resulted in the decision in Devesh Sharma Supra. In the above writ petitions by order number 3 dated 16/7/2021, a division bench of this court permitted the respondents to carry on the due process of selection and appointment during the pendency of the writ petition, but made it subject to the outcome of the writ petition, and also stipulated that the candidates selected and appointed shall be made aware of the pendency of the writ petition. Exactly the same situation. IA number 1 of 2021 filed on behalf of the interveners who were B.Ed qualified to implement as party respondents in the main writ application was disposed of without allowing the prayer for impleadment, but reserving liberty to file afresh if the need arises. However, the applicants were permitted to assist in the matter, and it was also directed that the learned counsel would be sent a link of the proceedings for online hearing. In further including petitions seeking permission to be included as petitioners to support the cause of those qualified with a diploma in elementary education was rejected. But yet another division bench as per order number this and this. Now, your lordship may kindly come to para 6. A preview objection was raised insofar as the selection having been proceeded with and appointments having been carried out. The lordship are getting para 6.
Page 45.
Please come to para 6, the very same position. A preview objection was raised insofar as the selection having been proceeded with and appointments having been carried out, none of whom are reported to school. However, it has to be noticed that the selection was proceeded with on the basis of the amendments made to the rules of the state in accordance with the modification brought about to the essential qualification by the NCT in the year 2018 by virtue of interim order number 3 referred to. The division bench categorically observed in the said interim order that the pendency of the writ petition shall be intimated to the candidate selected and appointed, and they shall not claim any equity since that selections and appointments were directed to be carried out only subject to the outcome of the present writ petition. So, one of the very same position here, we challenge the state rules, we challenge the NCT notification, we also pass an interim order that the appointment shall be subject to the outcome of the writ petition, awaiting the Naresh Sharma's final verdict. The interveners who support the cause of near candidates are before us, and despite the pendency of the writ petitions having been communicated to the appointed candidates as bound by the government advocate, none except the interveners herein have sought treatment. Their cause being adequately educated before this court, there is no scope for any further directions to be issued for impeachment of the affected parties, who despite intimation of the pendency of the petition and their appointments, being subject to the final outcome, have not yet to get themselves implicated here. We proceed with the matter, especially noticing that the issue is no longer res integra going by the decision in Devesh Sharma Supra. Chief Nigaraj Moli, learned senior counsel, however, pointed out that though there is no specific.
All right, we'll continue on the next working day. What's that?
Sorry, Munat. Sorry.
There is some urgent matter which has been said. The supplementary list is coming in 2 minutes. For 2 minutes, you can continue.
On Monday, I'm taking the daily spot, then I'm paying for a pick on Monday time. Monday is the next one.
Because if I adjourn your matter, then I will have nothing, no work to do for the next 2 minutes or 5 minutes. I don't know what continue for 2-3 minutes till the supplementary list comes.
But we will also make our submissions that it can be distinguishable on facts in Devesh Sharma, and MP has its own rules.
Yes, you will get your chance on the next one.
So I should kindly now come to that paragraph.
You were where? Para 9?
Para 7.
7.
7 and 46.
Regard Moli, British Senior Counsel pointed out that though there is no specific express intent as available in the judgment, the fact that the Honorable Supreme Court, while deciding Devesh Sharma Supra, held in the operative portion found fault with the state government for not having permitted the VA candidates to participate in the selection that was notified in the state of Rajasthan. This action of the state was held to be improper since the constitutionality was not being decided at that point of time. This made the decision prospective in nature, and hence the instant selection and appointment carried out prior to the judgment would have to be upheld by this honorable court. So one of that's the very same position that whatever has been done should be saved. Then one of the kindly see further further support for the proposition of prospective overdoing. The learned senior counsel placed lives on Soumya Organics, Kailash Chandra Sharma, all these Maharaj. Reliance is also played on all these. Then your Lordship may kindly turn to para 13. At page 49. There, Maharaj, the Honorable Division Bench starts noticing the facts regarding coming out of this notification. We have to notice the notifications from there, Maharaj. Dealing with Ramcharan Maurya, Devesh Sharma, all those judgments. Now your Lordship may kindly come. Page 20, para 19 to 55.
Page? Right.
Page 55, no, page 55.
Page 58.
Yeah.
Para 24. Now the question arises as to whether there is any justification for the argument that the declaration made in Devesh Sharma Supra is prospective in nature. Soumya Organics applied the doctrine of prospective overruling and referred to Golaknath when the parameters of such power were laid down in first anger. It was noticed that Golaknath laid down that doctrine of prospective overruling can be invoked only in matters arising under our constitution. It can only be applied by the Honorable Supreme Court, and the scope of the retroactive operation of the law declared by the Honorable Supreme Court superseding its earlier decisions have discretion to itself to be molded in accordance with the justice of the cause or the matter before it. Prospective violation of the principle that the court moves the relief claim to meet the justice of the case. Justice not its logical but in its equitable sense. There is no such express declaration made by the Honorable Supreme Court in Devachar Bhattapari Lordship and Andy Borders. Much has been argued about the Honorable Supreme Court having noticed that Rajasthan government when issuing an advertisement had not included the qualification of the NCT, especially when they were made eligible as per the statutory notification of the NCT, which was also binding on the Rajasthan government. This impliedly indicates the prospective overruling is the contention raised, which we are unable to accept. The above observation was found in the context of Rajasthan High Court having set aside the notification dated 28/6/2018 in the operative portion of its judgment that the state government could not have ignored the notification of the NCT while issuing the advertisement. The Rajasthan High Court had been clearly stated that since the notification itself was declared illegal, the issue was only of academic value.
We'll take it up on the next page.
My lord, consider recording it as a part heard by the petitioners.
Case stands part heard. Let the case be taken up on Monday. Hearing the remaining part of it.
Grateful, deeply grateful.
Application state which has been filed today. Today, number so and so shall also be for deferring the hearing of this petition shall be taken up on the next date of it. Provided the other side agrees. Memory will fade. Also aware that they would probably time 3:30. You make your arguments concise, precise.
So we are opposing any kind of further adjournment. Deeply grateful.
Fixing 3:30 minutes.
My learned friend has created great confusion here. I will like to respond first. Then if anything is required, then therefore I just want to clarify that what
You are an intervener, Mr. Rupra. Interveners only have a right to audience. That is all. You are not the main. Well, so we are the main contesting respondent.
That's why I was simply suggesting in one case I am intervening.
Lordship still hear me not by inquiry has been allowed, not lordship will hear me after.
In the case
My lord has got the gist that why is there being so much of delay that is being caused, my lord. So 29th would be a good date to hear, my lord.
my lord, over the My lord, in the case of Vipin Kumar Reddy, please allow my ID 17229 today.
So we oppose any application being allowed in this stage.
And similar applications of Mr. Kishjan has been allowed. My application may also be allowed, lest I may again face some objection like this.
So we vehemently oppose any such application.
You are a
I am for that DA candidate who has been appointed this election commission in March 2023. And this person has become intervener in KC Nandan, but KC Nandan may not release the arguments here because of objection Mr. Gilliard has been taking. So, Lord, my humble suggestion that this application of mine to be arranged as a respondent may be today allowed. I'm sure my learned friend will not object to
I
that.
will hear you after you can distinguish this Patna High Court's decision.
Not Patna High Court,
he should have outside or disclose this fact that the chairman is under challenge to the Supreme Court. Statement, let me make my
We mean forget it. Forget it will be. Grateful was deeply grateful.